Hey everyone, this is Salam Malhotra. Today I want to discuss a couple of questions that's constantly nagging brand owners. When does trademark protection begin? And is there a difference between trademarks and LLCs? Let's start with when does trademark protection begin? Common law trademark protection always begins with a brand owner establishing their common law trademarks. A common law trademark exists when a brand owner begins using their mark, be it name, slogan, or any other source identifier in commerce in a particular geographic area. A mark is said to be used in commerce when there's intent by the owner to use the mark in the ordinary course of trade. Now, what does that mean? It means any kind of online sale, in-person sale, or any kind of proof that shows that there's an intent by the brand owner to have a continuous presence in the marketplace. A brand owner with common law rights can use the TM as a superscript next to their mark to show their common law rights. Although there are limitations in trademark protections for marks that only carry common law rights. For one, common law rights associated with the mark only exist in the mark's geographic area of use. So it's likely that a business with a similar name or logo, with no common ownership, different geographic area of use, no trademark registrations, can exist without impeding on each other's common law rights. Those limited rights could be at risk if a prior user with a similar identical mark can claim common law rights. It is always beneficial to consult a trademark attorney that can conduct a knockout or even a comprehensive trademark search to avoid the risk of future rebranding or even paying potential damages. In addition to running a clearance search, a trademark attorney can also assist with monitoring services to police competitors and new entrants who might be trying to take advantage of your brand's goodwill. State and federal trademark registrations. State trademark offices are often a cheaper and a faster option available to small businesses and startups. But the protection for brand owners is limited to the applied for state alone. Almost every industry has a digital footprint today, and limiting a brand's protection to a state would be brand development malpractice unless that is the only option available, and that is in a very rare case, usually CBD, cannabis trademarks, and other. Without proper protection, you as a brand owner are allowing competitors in different jurisdictions to co-opt or even build off your brand success. Federal trademark protection begins the day your application is approved. Although applying alone provides you with certain rights against a competitor where you can claim prior use. A federal registration allows access to the following: nationwide protection, public notice to competitors regarding your trademark's use, complete ownership of your brand, lucrative licensing contracts, ability to police your brand nationally and through the U.S. Customs and Border Protection, use of the R symbol, and much more. Now, to the last question, are trademarks and LLC the same? Always a common question whenever I'm consulting potential trademark clients. Trademark registrations protect brands, be it the name, logo associated with the goods and services mentioned in the original application. LLCs are business structures that usually protect the owners from personal financial liability. It is essential to have a proper business structure and adequate brand protection. Still, the two require different processes involving different government agencies. Trademark registrations comes with an upfront investment, but it ensures that a brand owner starts their brand development journey on the right foot. If you have any questions regarding your trademark portfolio, please book an appointment and let's see if Dirshi Law can help you realize your vision. Thanks for watching.